Your brothers divided the property among themselves. They have not even called you. They have not even informed you that they're thinking that it's their own property and then they have divided it. Now you want to claim your rights, but someone is telling that the division of the property have taken place before 2005 and now you do not have any rights, right? So let's discuss about this legal aspect, whether you have the right or don't have the right, and if you're having, to which extent you have it. So all these things I'm going to explain in this particular video. Kindly watch the video till the end. I'm sure you will get a proper legal insight. Most people believe that the Hindu Succession Act was amended in 2005, that the amendment gave daughters an equal right in ancestral property. So anything that happens before 2005, a sale, a partition, a family settlement, is done and closed. Now the daughter do not get any rights as such. This is the very argument that brothers also do. And in many cases, court also have accepted it, in fact. But there are three situations where this argument completely fails. And if your situation falls into any of these three things, you still have the valid legal claim and you can go ahead and then get your property. Yes, my friends. Let's understand what law actually says. The law that governs this is Section 6 of Hindu Succession Act 1956, which was completely rewritten, which was completely amended in the year 2005. Now it is Hindu Succession Act, Amended Act 2005. Before 2005, under Mitakshara Hindu law, only sons were coparcenary by birth. A daughter had no right to demand partition of ancestral property at all. But the 2005 amendment changes completely. From September 9, 2005, a daughter became a coparcenary by birth itself, equal to son, with the same right and same claim and same liabilities. But does this apply to transactions that happened before 2005? In 2020, three bench judges of the Supreme Court have answered this question. The court held that the daughter's coparcenary right is by birth. It doesn't matter whether her father was alive on September 9, 2005 or not. It does not matter whether she was born before or after the amendment. The right exists from birth. There's a right by birth and can be claimed from September 9, 2005. Now the saving clause. The proviso to Section 6 of 1 and Section 6 of 5 of the amended act says that the amendment will not disturb any partition or alienation that took place before December 20, 2004. That means if before if the partition has already taken place or the sale has been already executed, in that case, this rule is not applicable. So if the registered partition deed was executed before December 20, 2004, that partition is protected, in fact. A daughter cannot reopen it under the 2005 amendment. However, Supreme Court laid down these three concepts in Vineeta Sharma's case. So situation number 1 is this: oral partition. If brother claims there was an oral partition, a verbal family agreement, that is not saved under Section 6 of 5. The explanation in the Section 6 of 5 is very, very specific. The word partition under this provision means only two things: a partition deed duly registered under the Registration Act 1908, or a partition effected by the decree of the court. An oral partition, an unregistered memorandum, a palpatti, none of these are valid. The Supreme Court held that a plea of oral partition based on the oral evidence alone must be rejected outright. So this is very settled law now. The second situation is only a preliminary decree was passed. If a suit of a partition was filed and only a preliminary decree was passed before December 20, 2004, that is not a completed partition under Section 6 of 5. A preliminary decree only determines the share. It does not divide the property by mets and bonds. Right? So the partition is complete only when the final decree is passed. Until the final decree, the daughter can still claim her share in the pending proceedings. This is also very settled now. And the situation number 3 is, the partition deed was made without the daughter's knowledge or consent. A registered partition deed executed secretly without the daughter being made parties, without giving them any share, its validity itself is a contested question and must be go to trial. So this amendment and also through this case law, it is very clear that these provisions does not automatically protect an illegal or fraudulent partition merely because it is registered. So this is very, very important that you have to understand it. And with this, I'm ending this particular video. Thank you so much for watching.